Dr. David, and welcome to tonight's presentation. This is a Building Strength webinars presentation. Many of you have been on our webinars in the past, and we really appreciate your continual patronage. Our goal with these webinars, as most of you know, is to help present people, especially average people, non-healthcare professionals, with the best information, the most valuable information when it comes to health and wellness, so that you, the individual, will be able to make the right choices. You'll be empowered to make intelligent choices and take intelligent actions towards taking control of your health. And we've been doing this now for about, let's say now, 4 years. And we've been very fortunate to have had a lot of great support from several people around the globe. And recently we began to start looking at not just at the mere physical health, but really about all the other things, some of the other things that surround physical health, including, well, the environment, and including, of course, your finances, because believe it or not, that is causing a huge amount of stress in this day and age, a huge amount of stress. I was actually watching the program on Dr. Oz. It was basically showing middle-class families, otherwise happily married middle-class families, now having to go to the stores to get food, taking food stamps to the stores and going to charity organizations just to get food for their kids. Now, that's terrible. That is absolutely terrible. And a lot of it has to do with the way their finances were controlled or used in the past, but many of these things have happened because things were out of our control. However, it has happened. The most important thing now is knowing how to protect what you have and hopefully increase what you have. And we're very fortunate to be contacted by our presenter tonight, John Kenney, and I just love his philosophy. We've talked briefly a couple of times, and I just love his philosophy about helping people, helping empower people to take control of their financial health. So it's really with a lot of pleasure that we're bringing him in. He's going to talk about himself. He actually works in Washington State. He is a financial planning attorney, but I believe it's asset management, but I don't want to start saying things that I'm not sure about. So without much further ado, I'm just going to hand this over to John. And John, thank you so much for taking the time to do this.
Okay, so hopefully everybody can see my slides. And thank you for having me, David. I really appreciate you inviting me to speak with your guests and your members tonight. As you said, I am an attorney, and I actually have many specialties. And just a little bit about my own background. I am presently out in Washington State, and I practice all over the country for certain areas. I have a master's in tax law, which is really what that means is I was sick enough to go back to law school for another 2 years after the regular law school, sort of like a physician going back for a specialty medical practice. And basically my LLM, or master's in tax law, has permitted me to specialize in the areas of tax and estate planning, and more specifically even than that, the area of asset protection, which is an area that I've practiced in for about 12 years now. And I've seen a lot of changes, as many of us have, in our country over the last decade, from when I was a young attorney to now, where, I don't consider myself too old, but certainly have more experience under my belt. And many of these changes, as we all know, have occurred in the last 2 or 3 years with the crash of our economy and the bust of the real estate boom. And as a result of that, I'm seeing, as David mentioned, a lot more stress amongst my normal client base. And before that, I was more of a preventative type of planner, where we would be very proactive with our clients in protecting for future unknown events that would possibly occur. Now we're being a little bit more reactive because of what the economy's done, both to clients of mine who are business owners, who are real estate investors, or who are just plain folks whose houses, their mortgages had some adjustments because they had some creative mortgages, and things are now difficult for them to make their mortgage payments, or maybe one of the spouses has lost a job. So we're seeing a lot of different things in the last 3 years that really has affected my clients' mental health, and actually several of my clients physically have been affected by it, because depending on how well people handle stress, a lot of folks haven't been able to handle the financial distress and their own reactions to that over the last 2 or 3 years. So what we do is we provide counseling and tools that are legal tools, asset protection, estate planning, tax savings tools, to assist people to sort of weather the storm and get to better days and sunnier days for themselves. So without any further discussion about that, let me go ahead and give you some background about our practice. So my practice's focus, as I said, is on tax planning. I also do a lot of self-directed IRA and 401k consulting around the country. And really this is a specialized area where, as a result of a lot of people losing access to cash because lenders are not lending, they're now tapping their IRAs and 401ks to actually use those to invest in things like real estate, which are a great buy right now. Retirement distribution planning and protection, we do a lot of that. Business planning and transactions, asset protection, risk management, estate planning, and real estate law. The reason I mention all these areas of specialization and focus that I have is because they are all fairly well integrated. Many of the asset protection scenarios or client cases that I'm seeing are all sort of related to these areas. The one area that I didn't put up there that just in the last couple of years we've had to become experts in is the area of bankruptcy. And again, this is more as a result of having to be more reactive than proactive. And bankruptcy is certainly another tool in our tool bag that we can use to protect assets and protect people from lawsuits and creditors. So that's a very important factor that just within the last couple of years we've really had to focus more on. So let's just talk about asset protection. Asset protection, the general definition, is a method to use tools and techniques to legally protect yourself from future potential creditors. And the definition is very specific because typically, as I mentioned earlier, asset protection is very proactive rather than reactive. In other words, you're protecting against things that you may know could happen, but you don't necessarily know that they're going to happen. So for example, if you're a medical doctor, and I have many medical doctors all over the country as clients, statistically, I believe, there's a lot of different surveys and studies, but I've been told, particularly with ER docs and OBs, that the statistic is that 50 to 60% of those doctors will be sued at least once in their lifetime. So they're very proactive in planning for their future and making sure they set up the right protection and devices so that if they are ever sued, and for some reason insurance doesn't cover their malpractice insurance, or if they're, as it was the case with a local doctor here in the Seattle area, if the damages exceed their coverage limits, then they've got some backstop protection with asset protection. So future potential creditors is what we're generally talking about. However, as I said, there are some reactive things we can do after a creditor has already come to fruition, is already trying to attack you or your assets. Typically, asset protection is tax neutral. We'll talk later about some of the scams that are out there in the world, and unfortunately, many of the scams that you could find on the internet or from promoters out there, they will promise you savings, tax savings, incorporate in tax-free Nevada and never pay taxes again. Things like that are promised. So you have to be very careful because asset protection planning is neutral, and it shouldn't cause any extra taxes, nor should it really save you any taxes unless it's got a tax planning component also. So that's important to remember. And then the true value of any asset protection planning, as I have found in my years of doing this area of practice, is that if you do it the right way with the right professionals, it does work. And then the second one is sort of building off of that is that because the proper planning does work, it is a huge deterrent. And we'll talk about this in just a moment, but the deterrent factor is huge in asset protection planning. David, I'm not sure how you want to handle questions. We didn't talk about this, but perhaps maybe at the end of the presentation we could take questions, unless you want people to type in questions during the presentation. It does not matter to me, but I'll leave that up to you on how you want to handle the question.
Sure. We usually leave them until the end.
Okay, wonderful.
But folks, you can type in your questions as we go along. So, and then we'll just collect them all and then ask them at the end.
Great. Thanks, David.
Sure.
So here's a little slide, and some of the statistics are dated. I've got some updated figures. Everybody knows I'm involved in a couple of lawsuits right now, involving a couple of trusts because I am an estate planning attorney also. And by no fault of my own, these are trusts that I participated in just recently, but the lawsuit was already underway. But the bottom line is that a lot of people in this country will sue somebody else or some organization or a trust, such as my case that I'm involved with right now. In fact, I'm in Portland, Oregon right now in a hotel room because I'm taking a deposition tomorrow of people that are suing this trust. But this trust has about $2.5 million in assets. And the bottom line is that when people see opportunities because somebody or something has wealth, they will take advantage of that. And that's kind of what our system has evolved to. And it's unfortunate because a lot of the attorneys out there in the country encourage this type of behavior. In fact, you can drive anywhere in any city and see signs that say you've been hurt, your doctor hurt you, you've been hurt in a car accident, sue, and you don't pay us until we collect. So it's sort of a system that encourages people to sue because they don't have to pay anything. So it's as a result of this, our system has grown and grown and grown, and it's an actual business and it's an actual economy in and of itself. And so you can see some of the statistics here. The interesting thing is I have looked up on the American Bar Association, which is the national organization that licenses attorneys, and the Bar Association stated that the litigation cases from 2008 are up about 20%. And again, that is indicative of the fact that when people lose their jobs, they want to blame somebody. And so I'm seeing in the last couple of years a lot more workplace lawsuits. So for example, I just represented a client who was a dentist, and this particular dentist had an employee who really just wasn't cutting it, and he terminated this employee. But he had done all the right things because we had counseled them, and he had received good counsel before us on documenting and keeping track of all the instances of deficiencies, coming to work late, et cetera, et cetera. So he did that over the course of a year. So he had a pretty good file, but nonetheless, you still filed a lawsuit. We were able to defeat that lawsuit, but that's the mentality that these folks have. Is she thought she was fired, and she claimed termination because of her age, which is a discrimination category. And she was older, but not older than 60, not younger than 50. But nonetheless, she had documented her poor performance versus her being able to prevail on an age discrimination. So there's a lot of workplace lawsuits because of the economy and people losing their job. And again, people just want to blame somebody. So there's a lot of things out there that cause lawsuits, and particularly now in a poor economy is what we're seeing. So I'm just going to go over some of the common things that I've seen in my practice over the last 15 years. I work with a lot of real estate investors, as I said before. So if people own investment real estate, whether it's commercial or residential, you've got people living in your property or businesses using your property that you don't know. And if something happens on that property, they'll sue you as fast as they can. So if somebody's injured, they're going to sue you. So that's a common thing that we see. Negligent management is sort of similar to premises liability, but it's a theory that you manage a property and you didn't fix the water heater, so the water heater blew up, so we're going to sue you. So these are things that are associated with rental properties and real estate. Environmental and hazardous waste. I have a couple of clients that own gas stations, and the common problem with gas stations is what they call dirty dirt. Now, dirty dirt is a plain, ordinary term, a layman's term for, an environmental hazard that's in the dirt because of a tank that's leaking. And as a result, there's no insurance that covers this sort of stuff. So because we had asset protection planning implemented, they are protected from the state when the state tries to come after them personally because they don't own the property, and that asset or that liability is contained and protected. Employment lawsuits I already mentioned. Business lawsuits. Business lawsuits are different than employment lawsuits. They would be, for example, if you have a contract with somebody and then that person violates the contract and you have to sue them, or worse yet, somebody sues you because of a contract. And I have to tell you, a lot of my clients, before they became clients of mine, were do-it-yourselfers. They started their own business. They created their own contracts. And I can almost always guarantee that when someone is writing their own contracts, there will be a lawsuit in the future sometime. And almost every lawsuit that I've worked on to help people with that's based on a contract was as a result of somebody doing it themselves and writing their own contract. So you have to be very cautious in a business setting to write good contracts. Professional malpractice. I mentioned earlier that I represent a lot of doctors. A lot of doctors are across this country. It is one of the biggest and growing concerns for doctors or of any type. Doctors, dentists, chiropractors. I represent a lot of chiropractors. And basically, it's the same scenario I mentioned before. When somebody has something go wrong, whether it's minor or major, they want to blame somebody. Whether or not it was a result of a pre-existing condition or something that happened after they left the doctor's office or dentist's office, they really do want to blame someone. So the first thing they do is they'll look to the doctor that treated them, and they'll try to sue that doctor. And as I said, ER docs are particularly high risk because the nature of their treatment is so quick and urgent, and there are probably more opportunities for errors and mistakes. But nonetheless, professional malpractice. It doesn't have to be in the healthcare setting. It can be in the setting of an attorney. This case I'm working on that I just mentioned, there is an attorney involved, and one of the allegations against the attorney is professional malpractice. Well, that individual may have to pay up, or his insurance may have to pay up. So any sort of profession has the risk of malpractice, and there are different levels of risks with those with these various professions. Contract breaches, I won't go into that. Car accidents can happen all the time. One of the things that a lot of people don't think about is if you have young children, 16 to 20 or even 25, if you own that vehicle and you let them use that vehicle, guess what? You're liable personally, potentially, for that young driver. And we've had some incidents out here where young drivers, of course, everybody probably knows of a scenario where a young driver goes out on a Friday night and parties with their friends and has mom and dad's car and has too much to drink. They wrap themselves around a tree. A couple years ago, just locally near me, there was a kid that did this, and one of his passengers was killed. Well, those parents of that driver had to answer and had to pay that lawsuit well above and beyond their insurance coverage. I think the coverage was $100,000, and they lost $5 million or so. It was huge. So devastating type of lawsuits. And finally, as I mentioned earlier, what we're seeing a lot of these days is a lot of my clients, whether they're real estate investors or whether they're involved in their primary residence with a very creative loan, a lot of these folks are in distress. And as a result of that, they can't make their mortgage payments. And as a result of that, they either short sell a property, which means they sell it for less than they owe, or they actually let it go to foreclosure. And so we're seeing a lot of what's called deficiency judgments or deficiency actions. And what that means is the lender will actually sue the borrower and actually go after the difference of what they're owed and what they actually were paid when the house sold or when they foreclosed and sold it. So there's a lot of different types of liabilities out there in the world, and I'm sure many of you can come up with many of your own. These are just some of the most common that I've seen in my own practice over the last decade, 12 years or so. So I'm going to focus on real estate right now, and owning real estate, as I mentioned earlier, can be risky. And it's very important that everybody understands this if you have investment real estate, whether it's residential or commercial. And so there are some things that we do and some things that we can do for people when they have real estate. One of the important things that we do with our clients and that I try to emphasize and teach and educate my clients about is to know the difference between the different types of assets. So I'll give you an example. There are two broad categories of assets that we use or that we classify in the asset protection world, and we call them risky and safe assets. And a risky asset is exactly as its name implies. It's an asset that has physical attributes that can injure somebody. So a piece of real estate, for example, the piece of real estate with the underground storage tank for gas or oil. A lot of my clients are private pilots. I have a lot of pilots as clients, and unfortunately, I guess fortunately for them, but unfortunately, airplanes have a lot of risk. We all read occasionally in the newspaper where a small plane goes down, and sometimes those people have passengers with them. Sometimes they crash into a house. Well, guess what? there's a lot of liability, because when one of those planes goes down, it usually results in death. And so all those passengers' families can sue the family of the pilot and the owner of the plane. So those are the inherently risky assets, things that can actually cause physical harm. To contrast risky assets, we have those assets that we call safe assets. Safe assets are exactly as the name implies, things that cannot physically injure somebody. A perfect example would be a wad of cash, or a bank account, or a mutual fund account, or a stock, or a bond, or anything like that that basically cannot physically injure somebody. So those are important concepts to remember, is the difference between risky and safe assets. And when doing planning for clients, we always have to keep the different asset classes in mind so that we can plan properly for them. The next thing we always have to worry about is the concepts of inside and outside liability. Now I have, this one's a little harder to grasp, but hopefully I can explain it. When I'm in the Navy, I'm a Naval Reserve officer, and I served my first 3 years as a lawyer on active duty as a JAG officer. And one of the things that was really neat about being in the Navy and still being in the Naval Reserve is when you go on board a ship, all of the ships have compartments. And every compartment has a hatch that has a big wheel on it. And anybody who's watched a movie from the World War II era understands what I'm talking about. But basically, the hatches can be closed and spun so that they lock down tight. Now, I didn't get this, and I didn't realize this until I actually joined the Navy. I was a kind of slow kid. But I didn't realize that the reason for that is when a ship gets hit by a torpedo or has damage, a fire, or a hole springs a leak, they can actually shut down that particular compartment and compartmentalize the damage, and it's called damage control, and they keep the flooding or the fire or the damage in that compartment. And the reason is why, because they don't want it spreading to the rest of the ship. So that's the best example I can give you to help explain the concept of inside and outside liability. The liability or the risk or the damage that's inside the compartment, that's called an inside liability. You want to keep that inside liability from escaping. Okay, you want to keep it from going out and affecting you personally and affecting the rest of your assets and the rest of your wealth. So that's an important concept to remember. It's the liability of the damage that's inside the compartment. An outside liability, by contrast, is something that's outside of that compartment. So the best example I can give is a car accident. A car accident anybody can have on any given day. And basically, that's an asset that's outside of all of your other assets, an activity that's outside of all your other assets. But because of that risk, that liability, that outside liability, it can affect your whole life, and it can go and infect all of your activities personally and all of your wealth, your business. So if you have a bad enough car accident, that could be a huge outside liability. So when we're doing asset protection, we really want to focus on how we can keep the inside liabilities contained, damage control, remember the ship analogy, and how we can prevent the outside liabilities from going after or seeking liability recovery from any of your assets or you personally. Okay, so that's very important. The last very important thing, and this is one that's really difficult right now, and the reason this is difficult is because I have a lot of clients, particularly the real estate investors or people who are upside down in their loans and can't pay those. I have a lot of people come to me and say, John, I'm about to get foreclosed on, I'm about to get sued by the bank. What can we do? And it's very difficult because there is a law, and every state has these laws, that basically says if you transfer your assets in anticipation of being sued in order to avoid your creditors, the judge in the lawsuit can actually remove those assets from wherever you place them. You give them to your brother, you give them to your mother, you put them in a special trust or LLC that we'll talk about in a moment, and basically a judge can remove all that, eliminate all that. So we have to be very careful because we don't want to, have our clients spend a lot of money with some sort of false idea of hope that they're going to spend all sorts of money and be protected. So this is something we're always cautious of, is this fraudulent conveyance law. We don't want our clients to lose their assets, at least without having some informed consent about the risks there. So real quickly, I'm sure that anybody who's ever heard of asset protection has heard about Nevada asset protection. Nevada asset protection is probably the most promoted type of asset protection in the country. And in fact, most of the people that promote this asset protection, incorporate in tax-free Nevada and do Nevada corporations for asset protection, most of them are not attorneys, which should be a huge red flag, huge red flag. And as I explain it to clients, if you go to get brain surgery, you don't want a non-licensed doctor operating on you. I mean, that's an example that everybody understands because it's so duh. Yeah, of course not. Well, same thing goes with the legal world. You don't want non-attorneys selling you junk and setting up this junk for you because it's probably not going to work. And there's a number of reasons why it doesn't work, and I don't go into those too much. But the problem with some of the Nevada asset protection is in the late 90s and all the way up to the mid-2000s, a lot of the folks who promoted asset protection in Nevada were actually also telling people they can avoid income tax using a lot of these structures. And the bottom line is from about 2004 or 5 on, the department or the IRS has basically shut down a lot of these promoters and have actually thrown a lot of them in jail and fined a lot of them because of the promoting of a tax shelter and tax evasion. In my research and my discovery of the case law and the state law down in Nevada, there really are no added benefits over other techniques that you can utilize in your own state or other types of techniques you can utilize. And the reason is because to really get the full benefit of a Nevada asset protection type of plan, you really have to be a resident of Nevada and or your property investment accounts or real estate have to be physically located in Nevada. So that's really the only time I see the added value of having Nevada asset protection is because you actually live there or your assets are located there. So I'll leave that behind, and certainly there may be reasons to do asset protection in Nevada for somebody, and I've actually done it before, but that was because they own real estate down there. So hopefully nobody just calls up NevadaAssetProtection.com and takes advantage of their services. Excuse me. So these are a lot of the common asset protection tools. Certainly the scope of this presentation is too general to go into too much detail on any of these, but I'll kind of briefly talk about them. Marital agreements. This is probably one of the most fundamental and basic asset protection tools that a lot of people overlook, particularly people who are older and whether they've been married or in a second marriage or not married, and they have assets of their own and they're proposing to get married to somebody else. Having a good premarital agreement is really important because what happens often, as many of us probably know, a lot of those second marriages or even first marriages that happen later in life end up in divorce, sadly. And so what happens is because there was commingling of the assets or they didn't get the agreement written up, then of course somebody's going to lose out, and of course the only people that gain in a divorce are the attorneys, and it's unfortunate. But marital agreements are a very basic, fundamental tool. Insurance. I'm not going to go into captive and offshore life insurance, but bottom line is I believe in insurance. I believe in liability insurance. It's fairly reasonably priced. In some cases, I've seen some of the commercial policies go up a lot in the last 5 years, but it is the first line of defense. And so I don't ever recommend anybody go without even the basic levels of insurance. You start getting into some extra limits and things like that. Maybe you want to go without bumping up your coverages too much because a lot of times people don't understand when the insurance folks are trying to convince somebody to get higher limits on their insurance. What you're really doing is you're giving the plaintiff's attorneys and the litigation attorneys out there more incentive to sue you. So if you bump your automobile policy from 100 to 500, guess what? That gives them more to go after. So a good, modest, and reasonable amount of insurance, liability insurance, is always recommended, and then some good asset protection to back that up. So I'll leave that. Workplace employment policies and agreements. I mentioned earlier the case I worked on with the woman who sued a dentist client of mine who was claiming wrongful termination because of age discrimination. Because he had policies and procedures in place and proper agreements, he avoided that lawsuit, and we got him out of it pretty fast, so that's important. Corporations, a very old business entity, and they're used very commonly to protect people's assets, and in the right case, they might be advisable. But we'll talk later about limited liability companies, also known as LLCs, and they're typically now the business entity of choice. Real estate equity stripping. Equity stripping is a technique where people who have, there aren't many of these folks, but anybody who actually has equity in their real estate these days can actually take it out in a manner such as a home equity loan, and actually can place that cash into a structure that's actually more protected than their personal residence. Because personal residences, depending on the state that you're located in, can be fairly unprotected if you've got equity. So there are some techniques we can do to protect someone's personal residence, equity stripping being one of the most common techniques. Land trusts, there are many, a lot of people out there that promote land trusts as the end-all, be-all to every real estate problem you've ever had. Don't want to pay real estate taxes anymore, start a land trust. Don't want to transfer or have problems transferring your real estate with a deed or paying an excise tax or sales tax you transfer, get a land trust. You want to protect your assets from everybody and everything, get a land trust. It's just not true. A land trust has very limited uses. The best use I can think of is in a state like California, where limited liability companies are charged $800 a year just to exist. That's a very expensive way to protect real estate. So what we'll frequently do is we'll create a land trust, which doesn't have to pay anything to the state, which is then owned by an LLC, such as a Nevada LLC or Washington LLC, depending on where the client's home state is. So a land trust has very limited use, and don't ever buy anything from somebody selling a land trust as the end-all, be-all tax savings and asset protection structure, because it really isn't. Personal residence trust. Here's another technique that we can use to sometimes protect the equity in a personal residence. Personal residence trusts have long been recognized by the IRS and the tax courts as a legitimate way to reduce estate tax and transfer your residence or vacation residence or any of your personal residences. You could have 5 all over the country, as a legitimate way to pass those residences on to your children or any other family members. And so as a result of having years and years of case law in the courts and tax courts, these are fairly well respected as an estate planning and wealth transfer tool, and as a result, they'll stand up to the asset protection scrutinization to protect a home if somebody is sued. So we utilize these frequently. Bankruptcy, I mentioned earlier, there's a whole lot we could go into on bankruptcy, but it is an asset protection tool in the tool bag that we always consider as sort of a last resort for clients. LLCs, limited liability company is the official name, but you'll hear me call them LLCs throughout the presentation. Family limited partnerships, you'll also hear me frequently call these FLPs. And then finally, asset protection trusts, and I'll conveniently call them APTs. And there's two species of asset protection trusts. There are foreign and domestic, and we'll kind of go into those and distinguish those in a moment. So real quickly, why most asset protection planners who know anything about asset protection love LLCs and FLPs. The reason is because of this concept called charging order. And a charging order is basically something that a creditor can go to a court and receive. Now the interesting thing is that I'm going to contrast a corporation. So if you own a corporation, or if you own pieces of a corporation like shares of Microsoft, generally speaking, if you're sued, the person who sued you can actually seize your shares of your own corporation, but it's your own little business, or if you had 100 shares of Microsoft with Merrill Lynch, they can seize those. Really very little to no restriction in doing that. The reason the LLC and the FLP are so phenomenal is because they have there's a law called charging order, and it's the only remedy that a creditor can use. And basically, it allows the creditor to collect from the entity anything that is distributed. Well, the beautiful thing about this is that the law also does not require anybody in the entity, the LLC or the FLP, to make a distribution unless there's a death, for example, and then there's sort of a mandatory distribution. But the law allows someone, again, just let me repeat that. A creditor can get money from the partnership or LLC, the FLP or LLC, if the distribution is made, but the law does not require a distribution to be made. So what happens is the creditor is sitting there wanting cash but cannot get it if if the people that own the FLP and LLC actually withhold it and keep it within the LLC or FLP. The other beautiful thing about the FLP and LLC is they can't force the sale of the assets of the LLC. So it has $1 million of real estate or $1 million in a bank account. They can't force the sale of the assets to collect. Again, their only rights is to a distribution if and when a distribution ever comes out. The other huge, huge deterrent to people that would sue someone who has their assets in an FLP or LLC is that tax law and tax courts have basically settled that anybody who holds this interest called the charging order interest must pay the income tax associated with that charging order, even though they did never get a penny of distribution or cash. So let me repeat that. A creditor holds a charging order. They're not legally able to get cash out of the limited partnership, the LLC, or the FLP. However, they must pay the income tax associated with whatever the earnings were of the share that they represented. So let's say, for example, they sued a partner who had 50% ownership of an FLP or an LLC. And let's say that charging order allows them to receive a distribution, but then we know that the FLP and LLC does not have to make a distribution, so they get no cash. On the other hand, tax law requires that if that LLC or FLP made $100,000 of income in that particular year, that $50,000 of that income is reported to the person who holds the charging order, and they must pay tax on it, even though they didn't get a penny of cash. So, as everybody can probably imagine out there, this is a huge deterrent for making people go away and not sue you, or in some scenarios, settling for pennies on the dollar. You know, they've got $100,000 judgment, you give them 20 to go away because they don't want to keep paying taxes for the next 10 years. So this is huge, and this is why FLPs and LLCs are really strong asset protection devices. So let's talk about LLCs a little more in depth. It basically creates a barrier between you and your asset, or you and the activity. Remember the analogy I gave you of the ship's compartment. An LLC is like the compartment with the hatch, and the LLC contains a risky asset within it. Okay, so that's important. The other thing that's really important is it's also a barrier, using the charging order protection theory that I just talked about in the previous slide, from outside liabilities and outside creditors. So if you've got $1 million worth of real estate inside an LLC, the charging order protection will protect it from the outside creditors. So it's both a barrier against the real estate or the airplane or the risky asset leaking out and damaging or going after you personally or affecting your other assets, creating a force field or a compartment around the asset that's risky. And it's also a barrier against outside liabilities and outside creditors for trying to get your asset out of the LLC because of the charging order protection. They're easy to use. Most states don't have very strict requirements on what you have to do each year. To contrast that with corporations, corporations have a number of very strict things, formalities they're called, minutes of meetings. They have to have meetings each year. And if you don't have meetings and keep minutes and those sorts of things, then your creditors can sue and go after the assets inside the corporation. Or worse yet, if your corporation creates a liability because it has a risky asset, the creditors can do what's called pierce the corporate veil and sue the owners personally and go after their personal assets. And that's, again, as a result of not obeying the formalities. Well, the LLC statutes and laws in most states have eliminated most of those formalities. And so they're very nice structures for the lazy people like myself who don't want to have a lot of administrative work, you know, just checking the box each year just for the sake of doing it. And then, of course, you're not at risk from being sued because the laws say you don't have to do that. We typically will use LLCs for owning real estate, as I've mentioned a couple of times. We also use them to own risky assets. I have many clients, as I said, with airplanes, and their airplane will be owned by an LLC. Same with boats, although I've had a lot of clients lose their boats recently, but definitely if you have a boat and people are using it, guests and such, then you may want to put the boat in an LLC. And then finally, we also use these for real estate management companies, and I'll sort of go over that in a moment here. So family limited partnerships. We use family limited partnerships for protecting a client's safe assets. So things such as cash, stocks, bonds, mutual funds, those are safe assets, as you recall me telling you earlier. And the safe assets are things that you want to protect from your risky assets. So the idea is you put your safe assets in the FLP, and then you put your risky assets in either one or more LLCs. So I have a client that has 128 rental properties. And what they do is, we actually didn't set up 128 LLCs. We looked at all the equity they had across all 128 properties, and we basically placed about 5 or 6 properties in about 20 or 30 different LLCs, and we balanced the equity across all those LLCs so that in any given LLC, they don't have more than $100,000 to $150,000 of equity at risk. And then what happens is they have a real estate management company, as you'll see in a moment how that works, that collects all their rents and does all the repairs so that they personally are not at risk for being the fix-it person to go fix the hot water heater, or they're not the manager, or they're not the owner that comes around to collect the rent. It's the management company that collects rents, pays expenses, does all the repairs, etc. And then all their excess cash, as with many of my clients, will go into an FLP, which is where you want your safe assets. So that's sort of the nucleus of a plan, is having a family-led partnership. Now, the beauty of a family-led partnership is just like the personal residence trust that I mentioned earlier, is a family-led partnership has been used for 50 years or more as a legitimate estate tax and estate planning and wealth transfer type of structure. And there's lots and lots of estate planning and tax court cases that talk about the protections of an FLP and how they're protected from creditors. So this is very important. And also, in some cases, if your children aren't as wealthy as you are, if you give interest in an FLP to them, the income that is generated from that interest will actually be taxed at a very lower rate. So it makes a lot of sense sometimes. If you're going to give money to your kids anyways, why not give it to them indirectly through the use of one of these structures, and it's taxed at their rate rather than you giving it to them with your after-tax dollars that's taxed at your rate. Again, just a technique that we use to transfer wealth, but certainly every case is different, and we identify each opportunity separately. So I'm going to take a breath here. The next thing we talk about is domestic asset protection trusts, or APTs as I like to call them. There are several states listed here, and I think by now there are a few more states, maybe 3 or 4 more states. But basically around the early 2000s, I think Alaska was the first state, and then Delaware was right there with them, because Delaware is always on the cutting edge of these things. And basically they enacted laws that said if you set up a trust in our state that has all these, all the provisions that are required, you can protect your assets in these sort of trusts. And just so that everyone's aware of why these laws are important, is because in most of the other states that don't have these laws, the laws are exactly the opposite. If you set up a trust for yourself, if you set that trust up for yourself and it's for your benefit, it is accessible and is unprotected from your creditors. So that's the general rule in probably 39 or 40 of the 50 states. So that's important to remember. And what these states did is they said, no, we're going to create a law that says if you set up a trust for yourself, for your benefit, with your money and with your assets, if you do it the right way and according to our laws, we'll protect those assets from your creditors. Now, a lot of the experts, a lot of guys that are out there in the world and gals who are smarter than I, have identified many potential problems with these trusts. And quite frankly, they have not yet to be tested, at least in cases of the magnitude where they would be reported in the reporters that actually report case law. But nonetheless, there are some potential problems here. The biggest one being the U.S. Constitution, which is the highest law of our land, which basically says if a judgment is received by a creditor in Washington State and you have an Alaska trust, the state of Alaska has to honor that judgment, regardless of what their own little creative little trust law says. So again, this is yet to be tested, but this is the concern amongst a lot of folks. The other thing is that the laws in these states typically require, and this is something a lot of people don't know about. Most of the laws require that the property, your assets, be physically located in that state. So that means if you set up an Alaska trust, your bank accounts, your investment accounts have to be moved to a trust company or a bank up in Alaska. It's a little more problematic with real estate. You can't physically move a piece of real estate. So there's a lot of concerns, particularly with my clients who own a lot of real estate, that if they have real estate and they set up one of these types of trusts, well, guess where the real estate's located? it's located in the state where they live or where they own the real estate, and that state doesn't have the protection of these laws, and the courts in that state are going to say, we don't care about Alaska, this is Washington, or this is Utah, or whatever. Actually, Utah's one state. This is your state, and there's no laws like this, and your real estate's located here, and you're located here. So that's really important, and so some of these things, again, is a domestic asset protection trust better than nothing? Absolutely. Is it the best? Probably not. There's another thing that we're going to talk about here right now that's better than a domestic asset protection trust. Now that's the foreign asset protection trust. And again, it's an APT as I like to call it. And basically the foreign asset protection trust is sort of considered the best asset protection in the world. So if you consider a family limited partnership and an LLC sort of the entry-level asset protection in the United States, and the domestic asset protection, such as a Delaware trust or an asset protection trust, the best asset protection trust or asset protection you can get in the United States, the foreign asset protection is strongly considered to be the best asset protection you can get in the world. Basically, the idea and the concept is that it's set up under the laws of a foreign jurisdiction, typically countries such as the Cook Islands or Belize or Nevis, that has a long history with their law and tested in the courts of their jurisdiction, where basically your assets, if they're liquid assets such as stocks, bonds, or mutual funds, they can literally be wired out of the country to a foreign bank account in an account under the protection of your trust. Of course, if it's real estate, it's the same problem that you have with the Alaska scenario I just said. Your real estate can't be moved to a foreign country. So typically what has to happen is you have to rely on the LLC to protect the real estate, or you have to sell the real estate at a huge discount, sort of a fire sale price, which a lot of people are unwilling to do right now, and actually take the cash proceeds and then get those out of the country. So, these are important. A lot of people I have use these. They want the peace of mind and the protection that, knowing that if the U.S. court system tried to go after their assets, they could literally remove it out of the power of the U.S. court system. And that's the idea behind the foreign APT is you literally, the U.S. system does not have power to take those assets anymore because they've been moved out of the country under the laws of a foreign jurisdiction. So what I'm showing here on the screen now is, I like pictures. I like to use drawings and pictures to explain things to my clients. This is sort of a typical plan for real estate investors. You can have any sort of risky assets over here in these LLCs that are off to the side. The management LLC is in the middle. It collects the rents from the properties, and that cash flows into the management LLC to later be distributed to the owners. Down in the lower corner here to the right, you will see that there is a revocable living trust. Now, we didn't talk about these tonight because there's a whole presentation that I do on estate planning, and we talked substantially about a revocable living trust, but it is sort of a common estate planning tool for most of my clients to use. And so the idea being that the whole plan, if someone dies, will be distributed according to a client's wishes through their revocable living trust, avoiding probate, maximizing the avoidance of estate taxes, etc. So this is sort of a general setup for someone who has real estate. If you can imagine the client I told you that had 120 plus rental properties, 20 or 30 of these LLCs off to the left, that's their setup and that's what they've got going. So it can get crazy, but it's also beautiful because we can minimize the income tax impact, and actually we can usually get it down to only one tax return being required to be prepared if we can talk to the CPA and set it up the right way. So using holding companies and such, we don't have to have a separate tax return for all the different LLCs, which is really nice. So here is a sort of a schematic of sort of the ultimate asset protection plan, as I call it. Again, these are just general overviews, but this would be the scenario where someone has a lot of liquid assets, and those liquid assets would be held by the family limited partnership, the FLP. The rental income would still be collected by the management LLC and then would pour into the FLP. The stocks, bonds, mutual funds, and other safe assets, remember these are safe assets, would be owned directly by the FLP. And then the FLP would directly own all of the real estate holding companies. And again, you could say they're real estate holding companies. You could say they're airplane companies. Everyone, has 2 or 3 airplanes, or an airplane and a boat, or you can have investment real estate and an airplane and a boat. So again, it's going to hold all the LLCs that own all of your risky assets. And then in the upper right, we've got the foreign APT, the Foreign Asset Protection Trust. And basically what happens is the same scenario happens if someone dies. Their family revocable living trust will receive their assets so that there will be an orderly passing to their heirs and family members without court intervention and minimizing estate taxes. But then if there's a crisis, what happens is all the liquid assets will leave the country via the foreign APT and are securely taken out of the country. And then, of course, if there's equity in the real estate and the client desires to sell the real estate can be sold, and then again, the real estate proceeds will then flow up through the family limited partnership and out of the country using the foreign APT. So, and then at death, the foreign APT can actually pass things back to the revocable living trust down below as part of the estate plan. So, again, these are general concepts, and certainly don't want everybody to go out and try this yourselves. As everybody can see, there's a lot of different areas of overlap here. We've got estate planning and trust, tax laws, business structures, transactions, fraudulent transfer laws, asset protection, real estate. And as I mentioned earlier, now we're really considering the bankruptcy laws because people are coming to us so close to being at risk from a creditor that it would probably be a fraudulent transfer. So we have to look at the bankruptcy laws to protect their assets. And so, doing it yourself or doing it with a planner that does not understand these techniques and does not understand what they're doing can really be problematic for you. So it's important to work with an expert, and whether it's us or one of the other experts around the country who's truly known as an expert, make sure they're an attorney. Folks that do this that are non-attorneys really don't have all the tools in their toolbox to be able to handle this. Remember, it's like the analogy that I used earlier that having a brain surgeon operate on you, a licensed brain surgeon, rather than some person who's just claiming to have a little experience, slept at a Holiday Inn Express last night, as the commercials say. So it's really important, again, as I said, and I'm happy to take anyone's questions now. And if anybody wants to contact me independently, I do complimentary consultations. And here's my email address. Actually, that's the incorrect email address, but certainly that is forwarded to me. I didn't update this. And there's my phone number. And I'd like to take questions and open up for questions now, David, if we can. You there, David?
I'm here, John. Sorry about that.
That's okay.
I had muted. Apparently, I muted myself in 2 places, on the phone and on the system, and I only unmuted myself in one of the places. Why don't we leave it? Why don't we leave it on that? Let's leave your slide off.
Yeah.
In the meantime, thank you so much. That was great. You covered a lot of ground within the short time that you had, but you treated the important parts very well. So we appreciate that. So folks, you can go ahead and type in your questions in the top right. And many of you know the drill. The top right corner has the questions box where you can type in your questions. We actually have a couple of doctors on this call as well, so I'm sure they will be interested in getting more information on this, and some nutritionists as well, people who have clients, who work with clients, healthcare-wise. So I'm sure we'll have some questions. Okay, Debbie is wanting to know if any of this is applicable in Canada. This is mostly has to do with the United States law, isn't it?
So Debbie, I didn't hear all of what you said there. So she wants to know if this applies in Canada?
Yeah, her exact words, how much of this would be applicable in Canada?
Yeah, the only thing that we could implement for a Canadian citizen, and we probably want to associate with a local council, would be the Foreign Asset Protection Trust. The Foreign Asset Protection Trust can work for any citizen of any country, and that's something that we would talk to Debbie about, for example. But we'd also want to talk to perhaps a local attorney to make sure that she has some good estate planning there based on the Canadian laws and the province where she lives, and that we don't screw that up somehow. I mean, the last thing I want to do is mess up someone's estate planning or other planning by putting an asset protection trust, foreign asset protection trust, without talking to local counsel there. And, I've got friends up in British Columbia and attorneys that I've worked with up there, and certainly it's just like the U.S., all the provinces are different from province to province as far as the laws go. So we'd have to talk with someone in Debbie's province to work with them on that. But the Foreign Asset Protection Trust could certainly be used for Debbie.
Got it. And some accountants kind of they say they shy away from LLCs because of the tax disadvantages some of them may have. What do you have to say about that?
They shy away because of the tax disadvantages. Is that what you said?
Yeah, they tend like my accountant, for instance, said oh, LLCs you pay more taxes with LLC than so wanted to opt for more an S corp or a C corp. Yeah,
well let me just explain that. I actually, you're giving me all these segues to other presentations. I actually have a whole different presentation on business planning and business entities. But in that presentation, I actually go into the beauty of the tax benefits of having an LLC. And the reason is an LLC is so fantastic from a tax perspective is it is the most flexible of all business entities. It can be taxed as a sole proprietorship, which is the absolute simplest way to do it. It can be taxed as a partnership for tax purposes if you've got 2 or more partners. It can be taxed as an S corporation, which is a wonderful thing, as you've discovered, because there's a lot of benefits to being taxed as an S corporation. Or it can be taxed as a C corporation, which really isn't advantageous for a lot of small business owners. But again, the beauty of an LLC is organized under state law in any particular state. It can be taxed one of 4 ways for federal tax purposes. So very commonly, David, we will set up an LLC under a state law, and then we'll have a tax for federal tax purposes as an S corporation, which is the best of both worlds. And most of the accountants I work with will love that, because the LLC is very easy to use, vice a corporation with all the formalities. It has all these asset protection features, not like a corporation that doesn't have much of any asset protection values. And then it can be taxed any way you want it to be taxed.
Interesting.
Yeah.
That's interesting. Okay, well, our organization, Building Strength Webinars, is an LLC. But, okay, so it is possible to do it at the state level as an LLC and then as an S corp and then more national. I'll bring that up with him next time we talk.
Well, if you're already set up, you're allowed to do that election. You have to file some paperwork with the IRS in the first 2.5 months of your tax year, which is usually the calendar year. So talk to them now, because in January through about March 15th is when the IRS allows you to change from being taxed as a regular, you're probably taxed as a sole proprietor if you're one owner, and then you can become an S corp between January and March 15th of 2012. And then for 2012 and beyond, you can be an S corp.
Interesting.
Yeah, no, beautiful concept.
Thank you. Yeah, yeah. So, folks, any more questions? And we do have people who call in, obviously, so they couldn't see your wonderful diagrams, John.
Okay.
And those who we don't know, I haven't figured out a way to measure or track the people who call in. We just know those who log in.
Got it.
Yeah.
Well, I had a wonderful time, and certainly, David, thank you for inviting me and being such a gracious host. And I would love to, again, as we discussed earlier, talk offline about future presentations that we can present to your members that may be of beneficial value in other areas of legal and asset and estate planning and tax and business. So, again, thanks for having me, and I'm glad to answer any more questions still if there are out there.
Absolutely. Thank you for coming. Thank you for coming on. And yes, I know I would certainly be very interested, because this is such an important aspect of daily life. It's just becoming more and more apparent that it's so important to understand finances, especially in this society and in this economy we're in. It's just that important. We can't ignore it anymore. We can't. We just have to be financially literate when it comes to these things. So thank you so much for doing this. And yes, we will be talking more about getting John on for as many times as possible to treat all these different areas that you mentioned.
Great.
All right, well,
thank you.
Appreciate it. Appreciate it. And hope that the deposition goes well tomorrow, I believe. Is it tomorrow?
Yeah, it is tomorrow morning.
Okay. All the very best. All the very best. All right, folks, we're wrapping it up for tonight, and thank you for joining us. Be sure to join us for Helen's presentation on Thursday on how to help parents and teachers of kids struggling at school. And of course, you know Helen Owen is one of the best in the world when it comes to learning disabilities, visual processing problems, helping kids overcome those issues. So be sure to log in on Thursday and let people know about it, especially those who are parents who don't know what to do with their kids. All right, we're wrapping up. Thank you. God bless. Have a great evening. Good night.
Good night.